Well, good afternoon. Can I welcome all of you to a Red Lion Chambers webinar on health and safety. It is a roundup of health and safety law, largely for defence lawyers, although of course it's open for everyone. We've got quite a lot to get through today, and so if you'll forgive me, I'll keep introductions very short indeed. My name is Sailesh Mehta. Can I introduce you to Richard Beynon, our main speaker for today. Richard is, by any account, a heavyweight prosecutor. Richard has a practice that includes a range of regulatory law, including some serious and complex health and safety cases, as well as environmental cases. Can I also welcome and introduce Tom Davies, who's a junior member of our regulatory team. Tom has a wide-ranging practice involving crime as well as regulatory law. And so, without further ado, let's start on this webinar. We've got probably about 60 odd slides to get through. Can I assure everyone that if we don't finish all of these slides in the 1.5 hour that we've got, two things. Firstly, all of the slides with comments and with links have been prepared in a way that we can send them to you, and therefore you will have all of the information and more that you will receive at the end of this webinar at some point. Secondly, we are recording this webinar, and once it's edited in about a week's time, you will have access to it on our Chambers website. And thirdly, can I encourage you, as many of you, to ask questions by typing them out. We can't guarantee we'll get through all of them, but what we can guarantee is that we will respond to each of those questions after the webinar over the next few days. So, Tom, we've got, I think, 3 broad areas that we're going to be covering in the next hour and a half. The statistics, case law, as well as guidance. I think you're going to take us through some of the statistics first.
Yes, thanks very much, Sailesh. The first slide that we want to deal with today is the statistics around health and safety cases at the moment, and what the effect in particular of COVID-19 has been on them. Indeed, it wouldn't feel right over the last 18 months with all the presentation we've seen to start with anything other but the stats. So this slide here shows the general trend across 4 key areas, and that is a falling number of prosecutions, a falling number of convictions, a falling number of notices, prohibition notices and improvement notices issued, and a falling level of fines imposed. The key question is that decrease, particularly in 2019 and 2020, due to the COVID pandemic? And the Health and Safety Executive have looked at this very issue. The data collection period for 2019 and 20 fell largely outside of the disruption of COVID, but some reporting did fall within it. The picture, as you would imagine, is a complex and entangled one. COVID primarily affected the research and statistical measuring of health and safety incidents in 2 key ways. And that is, firstly, that there was a lack of reporting due to allocation of resources to deal with the crisis within businesses being shifted away from reporting and into managing the crisis. And secondly, the number of cases generally were dropping because people had down tools, so to speak, and the industries with which we are concerned primarily, in large part, stopped, as did much of the country. The Health and Safety Executive looked at their 2 prime data measuring sources, the labour force survey, and also the reporting of injuries, diseases and dangerous occurrences regulations. Taking the labour force survey first, There was disruption in this data gathering of this particular survey. In the first quarter of 2020, from January to March, there was an 11% drop in reporting compared with 2019. But notwithstanding the statistical adjustments that the ONS employed, the HSE's analysis demonstrated that there was still a significant increase in the rate of all workplace injury as between the years 2018-19 and 2019-20. Their analysis was that in relation to this resource, the number of reports that were coming through this particular channel, in the absence of COVID, there would still have been an increase in this particular source. So their overall conclusion is that COVID-19 did play a part in affecting the measurements, but it wasn't the only contributory factor. Their analysis really focused on how they couldn't reliably assess whether the increase was due to COVID. And their plan is to administer further questions in 2021 in order to gather further information that they can reliably measure. Looking at RIDDOR very briefly then, in this analysis, they conducted a month-to-month comparison in relation to 2019-2020. And it appeared that in relation to this index, which generally is the more serious with which incidents are reported, they were on track throughout 2019-20 to have been lower in the non-fatal injuries to employees over the year. But reporting in March fell dramatically, which they say may have reflected both a genuine reduction in the number of injuries, but equally it may be due to a fall in reporting. So again, their conclusion is COVID-19 is not the sole driver of a fall in injury reported, but it is likely to have accentuated the overall annual decrease in relation to this. I want to bring in Sailesh and Richard at this point, just to give us an idea of how in their practices, COVID has affected things, and in particular, the justice process generally. So if I turn to Sailesh first.
I think the general feeling, certainly at the criminal bar, is that there was devastation in terms of listing and prosecutions at the start of COVID. That was reflected in the huge increase in the backlog of cases, of criminal cases, particularly the serious criminal cases, which had priority. And of course, that had an immediate knock-on effect on almost every health and safety case, because those cases were seen to be less urgent because people weren't in custody. And so it's had a knock-on effect on any serious health and safety trial, which has now gone off till next year or even the year after that. Richard?
Yes, that's right. I think at the last count, it was about over 58,000 cases outstanding in the Crown Court. And from my own experience, cases that are beginning now are being put in a year hence, if not longer. There is also, I mean, I'm over COVID, I've prosecuted for the HSE, and I've witnessed firsthand, I suppose, the difficulties that the investigation has taken over that course, because of course inspectors haven't been able to go and make visits and so forth, certainly in the early months and during the lockdown periods, let alone of course the practical effect of presenting cases. I had a case quite recently where the public gallery is limited, extra video links via the CVP, the common video platform, have to be organized. very much dependent on whether there's a room in the courtroom or in the court building that can be accommodated. So, yes.
Thank you both. So turning then to the next topic, and this really is in relation to an analysis conducted by the Sentencing Council which was published on the 4th of April 2019 in relation to the effectiveness and appropriateness of the Health and Safety Offences Definitive Guideline, which was introduced on the 1st of February 2016. And what the Sentencing Council did was they looked at a 16-month period before the guideline was introduced and also after the guideline was introduced. And they compared a variety of data. They looked at fines the level of fines as compared with the company's house data available for certain companies. They looked at the content of the remarks made in sentencing to get an idea of how the guideline was being implemented at first instance. And they also looked at the Court of Appeal Criminal Division decisions, a selection of them, to see the effect of the guidelines on appeals. And their findings, really, the key headlines are the following 3 points. And that is that fines increased overall following the implementation of the guidelines. And in particular, that was the case for large companies. And to a lesser extent, smaller corporate bodies were being fined an increased amount. Secondly, the content analysis revealed that the guideline was generally being applied in the correct manner. And finally, fewer appeals were successful after the implementation of the guidelines. So some of the limitations, perhaps, of this analysis. Firstly, this is a Crown Court only and Court of Appeal Criminal Division assessment. It doesn't look at the Magistrates' Court, where many health and safety and prosecutions continue and are dealt with. Perhaps an obvious point is that the sentencing guidelines ensure that errors are more easily spotted and that decisions are harder to depart from because the framework is prescriptive by nature. So an interesting point here, I think it will be to bring in Richard, who has a good example of where in his practice the guidelines may not have worked so well. Richard, is that right?
Yes, it is. In waste law, the case concerned a fly tipper, a serial fly tipper. He was prosecuted by a local authority, in fact, prior to the guidelines being implemented. And his sentence of 2 years was upheld on appeal. When he was sentenced the first time around, he was made the subject of what was then an ASBO, now would be a criminal behaviour order or something like that. And so he was prosecuted for not only similar conduct, fly tipping, but breach of the ASBO as well. The judge, in applying the guidelines, despite what you may think are pretty aggravating features, sentenced him to 37.5 weeks. So it works out that you get less after the guidelines, or the environmental guidelines, than you did before. Doesn't always work.
Yeah, but generally, Tom, I think the picture is that the fines have been increasing. I can say that certainly in one of my cases, there was a £20 million fine about 3 years ago, and 2 weeks ago, £4 million fine. And neither of those two fines would have been imaginable about 10 years ago for the sorts of offences that I was prosecuting. The downside when you're defending because of these guidelines is that it makes it much more difficult now compared to pre-guidelines to invite the court to make an enlightened sentence, by which I mean a very soft sentence, because judges now know that while the Court of Appeal will back them to the hilt, they will only do so if they can be seen and demonstrated to have stuck to the guidelines. And even though the Court of Appeal constantly talks about the guidelines being just guidelines and that they're not straitjackets, of course the reality is that as long as the judge stays more or less within them, they become almost unappealable.
Thanks, Sailesh. So as we can see there, the sentencing guidelines working as they should, and as Sailesh says, increasing financial implications for clients. So we now come to the cases section of the talk, which we identified at the beginning. And the first case really to discuss, and there hasn't been many cases reported because of COVID, but the ones that have, that we feel are significant are here as a selection of what's gone on. And the first case is Ahmed and the Health and Safety Executive. And this was a case where the appellant sought to convert its 3-storey Victorian brick building from an office space into a shisha bar and restaurant. Virtually no sign in the course of that endeavour was there of any health and safety measures being employed. What essentially happened was they stripped out all of the supporting blocks and pillars within the wall without replacing them with any structural support whatsoever, temporary or permanent. An inspection by the council, unsurprisingly, led to a prohibition notice being issued. And shortly after the issuance of that notice, the roof of the building collapsed. Whilst fortunately no one was injured, there was widespread disruption and both to businesses and residents, and exposure to asbestos and live utilities. It was serious. The issue in this case was whether the appellant was in control of the site for the purposes of the regulations, the 2015 Construction Design and Management Regulations, and whether they were the employer for the purposes of Section 2 and Section 3 of the Health and Safety at Work Act. The appellant argued that, in fact, the principal contractor who was in control of the site for the purposes of the 2015 regulations was in fact the architect and building designer that he had engaged. And he also argued that in relation to the employer under the Health and Safety at Work Act, that was a business known as JM Builders as a set of independent contractors. That was a business that was a partnership between two of his co-defendants, significantly, and a third party. And what the court held was, in determining who is an employer, that there is a broad fact-based approach to be employed and a consideration of all the relevant facts and circumstances. I don't propose to read out the lengthy paragraph quotations, but suffice to say that the Court of Appeal upheld the trial judge's directions when they invited a response in the form of a question from the jury that they were unsure of the employer and independent contractor. And the direction the judge gave them of a broad facts-based approach for their judgment was correct. Now, it's a significant case, I would submit, because it's consistent, firstly, with the civil line of cases in relation to an employer, which we've recently seen restated by Uber and the case in the Supreme Court. And there, significantly, the court, in particular Lord Leggett, endorsed the approach in Carmichael and National Power, where the House of Lords invited tribunals to examine all the relevant evidence and held that the written documentation, such as a contract of employment, had no special evidential weight. The terms in particular, where it includes terms which purport to classify the relationship or to exclude statutory protections. And that may in particular be relevant for in instances where we're concerned with cases where there's a safe system of work provided by employers. There's plainly a need to provide a statutory protection in the form of the Health and Safety Work Act. And even if there was, say, a document trying to exclude that on the basis that they weren't an employer, then that would be plainly inappropriate. It's a factual analysis. And Carmichael was imported into the context of health and safety law in the case of Health and Safety Executive and Polar, which in relation to explaining what the bounds of the mutuality of obligations was in relation to casual workers, the court again relied on Carmichael. So it's consistent throughout both the civil context and the health and safety offences context.
Tom, I suppose on one view, this judgment just follows a line of authorities that goes back to Lord Denning's days. The key principles being, the court will not necessarily follow whatever tag any person has given to any other person. The court will look at all the facts of the situation. And of course, that's exactly what the Uber case did as well.
Absolutely. It's a line of authority extending all the way back to cases like ready mix concrete and all the famous ones we will know and love from our university days, I'm sure. So the next case is the Crown and Fireworks Direct and Mr. Dole, who was the director of that company. In essence, a fire broke out on a row of industrial units on an industrial estate. It was a terraced arrangement of units, and the fire was substantial. And there was a concern about the adjoining premises, one of which belonged to the defendant and operated the defendant company. Perhaps slightly ironically, I suppose, the fire officers were informed by the appellant's brother that the fireworks were being stored in their unit. And upon inspection, it became clear that there were serious failings in the keeping of those fireworks, including the content being 3 times the permitted limit. But not only that, as well as the manner of storage, their own fire safety systems were poor. So there was a real high risk situation where the fire was concerned. The defendants were sentenced to the matters you can see below the initial paragraph. An £84,000 fine for the company and 17 months imprisonment. And they argued that their sentences were manifestly excessive. But the Court of Appeal disagreed in quite robust terms. They simply didn't entertain the submissions of the appellant. And this is a significant case because it shows that it's an unusual outcome in health and safety cases for custody to follow. But what it demonstrates is that where there is a clear threat to life and the facts really warrant it, that the court will take a very robust approach. And this case is simply illustrative of that point. The next case is Places for People Homes, a very recent case. And this was a community benefit company who operated on a not-for-profit basis. They essentially ploughed their money back into the organisation's endeavours and didn't operate and were of benefit to a wide range of quite vulnerable people who made use of their services. The company were convicted of health and safety breaches and fined subsequently £600,000. They appealed that sentence and argued in relation to the guidelines for these offences. The judge took, firstly, the incorrect starting point. Secondly, that the judge failed to consider the organisation's non-for-profit nature at step 3 of the sentencing exercise. And thirdly, that the judge failed to make a sufficient downward adjustment to reflect the impact of the fine would have on their vulnerable beneficiaries. So in relation to the first question for the court, the short answer was no. At this point, I think it's going to be useful to bring Sailesh in, who has acted in the Thames Water case, which the court relied heavily on in order to decide that, or restate rather, the principles therein, that this was essentially a feature of the case, that the objectives in the guidelines are clearly defined. And with large companies, there will be a need to focus their minds from a shareholder's perspective and from a senior management perspective.
Yeah. So two or three very short points. Firstly, yes, of course, I've prosecuted companies that are known as very large organisations, and there's no guide to what amounts to a very large organisation, except that the turnover is substantially more than £50 million. But usually, it's like describing an elephant. Difficult to describe, but you know one when you see one. Just coming back, Tom, to the discount that one might expect in relation to if you're an organisation that's a charitable organisation or something of that sort. Are you going to be dealing with that next? Or?
Yes, I can bump through the slides now. So this is step 3, and that is the key points about step 3 are twofold. Firstly, the court needs to ensure that the fine reflects the serious nature of the offence, and in doing so, they will take into account the financial circumstances of the offender. And secondly, as I said previously, there's a real need to ensure that the sentence fulfills the objective of the fine, which is to have a real economic impact, which directs the mind of senior management and shareholders to the importance of health and safety legislation. And that in a nutshell is what step 3 is. The court held in relation to places for people's homes that step 3 wasn't the correct place to consider the not-for-profit nature. What step 3 relates to is the ability of the company to pay the fine. Plainly, the size of the company meant that it was in a position to pay that amount. The correct place to consider the question of whether the not-for-profit nature, what effect the not-for-profit nature would have, was in relation to step 4, which is the point where the court ought to consider the impact on beneficiaries of the organisation. So while stage 3 and 4 are interrelated in the question of determining the overall proportionality of a sentence, they are distinct exercises that the court must go through. And it's important not to conflate the features of your client's cases with one or the other and deal with them together and mix them around. They're very strict, prescriptive provisions within the guideline which direct the mind sequentially through those stages. But
well, Tom, may I just give a couple of examples of the workings of that step? I prosecuted and defended in 3 cases involving that particular section. 2 of them I prosecuted. So one was a hospice in which there was a fire and 3 people died. The court gave a significant discount. It was a discount almost a third off, because it was a hospice that was not for profit, etc. They still appealed to the Court of Appeal against sentence, and the Court of Appeal said no, the discount was sufficient. In a case that I defended recently involving a college, it was an agricultural college, the court was extremely moved by at that stage to reduce the starting point of the sentence. But we had to jump through the hoops for that stage, to show that it was a college, that it was not for profit, what the effect of a large fine would be. And the effect of our mitigation for stage 4 was that the college might have to close. And the court accepted that mitigation, therefore the sentence was hugely reduced. So it's a question of fact and degree as to each stage.
It's a very difficult exercise for the judge, though, isn't it, Tom and Sailesh? Because take, for example, a local authority that is in breach of the law in relation to hand and arm vibration syndrome, maybe over a number of years, which would have necessarily involved a large number of different workers. On the one hand, a heavy fine is what the local authority would deserve, but equally on the other, it's money that is really needed for local services.
Yeah, I prosecuted a case involving Walthamstow Council in London, and the court was less moved by defence submissions for a reduction because it was felt that even though it was a local authority, even though it was not for profit, that there comes a stage when a breach is so serious that it's the discount should be limited, and that's exactly what the court did.
The same happened in a case that I prosecuted as well.
Sorry, Tom, over to you.
No, not at all. It is a very difficult question. And indeed, this case, in fact, illustrates very well how the first instance judge may get it wrong. And in the event the court did feel that at step 4 of the analysis, the impact of the fine on vulnerable beneficiaries of this company would be so great that the fine ought to be reduced. And they did reduce it from £600,000 to £400,000. It's one of these difficult decisions of the common law way of doing things that we have to rely on a judge's decision-making powers, and where the guidelines are flexible in instances such as step 4. Unfortunately, there can be errors and room for appeal. So the next case is AH Limited, and this was a case that was primarily concerned with the reverse burden under Section 40 of the Health and Safety at Work Act. This concerned a company and a director of a care home. They operated a care home, and a resident in their care did suffer severe burns as a result of the incorrect type of thermostatic mixer valve tap being installed. And in the case, the judge conducted a preparatory hearing and gave a ruling on where the burden under Section 40 of the Health and Safety at Work Act lied. She found in favour of the prosecution that it was a burden that the defence bear, and the defendant appealed that ruling. And what the defendant argued was that the case of the Crown against Davies was wrongly decided. They argued that reasonable practicability, as you can see there, is an element of the offence, not a defence, and that Section 40 would inflexibly require the defendant to prove an element of the offence and therefore violated a presumption of innocence. And their contention was essentially that Lord Justice Tuckey had got the analysis wrong by failing to consider the approaches in 2 key cases that you can see there. Secondly, they contended that Lord Justice Tuckey blurred the distinction between elements of the offences and a defence when assessing Section 40. Thirdly, the court erred in its approach by concluding that Section 3 was merely a regulatory offence rather than a truly criminal one. Their contention was, the defence's contention was that this was an arbitrary reason to undermine the presumption of innocence, and placing the legal burden on the defendant in these circumstances was disproportionate. And finally, their contention was in relation to the modern day practicalities of health and safety investigations. And it meant that the nature of the reality of the situation that defendants face in the modern world, it means that the burden of Section 40 is disproportionate. They contended that it should be no more than an evidential burden. In relation to the director specifically, it was contended that when Davies was decided, they didn't have the opportunity to consider the fact that custodial sentences may follow, because they were subsequently introduced in 2008. However, the short point that the Court of Appeal decided was that Davies was approved in the House of Lords case of Chargo or Chargot, and plainly the House of Lords authority was binding. There was nothing disproportionate, they felt, in the reverse burden. And in relation to the director, that Chargo was decided when at a time when the House of Lords were aware of the fact that imprisonment may follow. And so the Court of Appeal felt that, therefore, they made the decision to approve Davies in the light of that and stood by it. It's not an uncontroversial decision, particularly because the Court of Appeal went quite far in supporting the case of Chargot, stating that even if it hadn't been to the House of Lords, they would have found it quite difficult to accept Davies was a wrongly decided case. So they have doubled down really on the reasoning in Davies, and so it seems unlikely that this area of the law is going to change, I consider, for some time. Richard, if I could bring you in for your thoughts on Chargot.
Well, Chargot, isn't it? Question for the House of Lords there, of course, was what does the prosecution have to prove to establish criminal liability? And according to the prosecution there and the House of Lords, very little. The mere fact that there's an accident at work raises a presumption that the employer has failed to comply with his duties under Section 2 and Section 3 of the Health and Safety at Work Act. To put it as Professor Spencer does, whenever an industrial accident occurs, the employer is guilty unless he can talk his way out of it.
That's a very succinct way of summarising one of the most important House of Lords Supreme Court decisions in recent times. Well done, yes. Richard. How are we doing for time, Tom?
Good. We've got one final case, the case of Connors, before you'll all be relieved to know that I'll be passing over to Richard. Connors was a case where an employee was very badly injured at work in a saw accident. And the key point about the evidence in this case is that it was concluded by the experts that the risk gap, that is the actual risk that was present compared with the benchmark risk that was acceptable, was said to be extreme. And essentially, the defendant made an abusive process application, which was rejected by the judge. And they contended that that decision was wrong and that the judge should have acceded to the request to stay. So they made their arguments on the basis primarily of two things. Firstly, that the public interest in prosecution hadn't been met by reference to the enforcement policy statement or the enforcement management model that the HSE employ. And secondly, that it wasn't proportionate to prosecute because the company would be adversely affected in a retendering process. Or maybe. And that retendering process concerned it's their only client and therefore they're at risk of insolvency. Connors is a straightforward ratio and in my submission, plainly the right decision. A different standard of review in HSE proceedings would be highly undesirable, the court felt, and anomalous. As I said at the beginning, the significant point was that the extreme risk gap in the case meant that the public interest conclusion by the prosecutor was justified, notwithstanding that less severe means of enforcement were available, in principle, the reality of the situation was the company had essentially got rid of the machine that caused the accident, and so that lesser mean of enforcement would not have done any good. In relation to the enforcement, the proportionality question, the wind was rather taken out of the defendant's sails because it transpired in the event that they were in fact successful in their retendering process, which vindicated the decision of the trial judge that the contention that they may fail and were at risk of insolvency was purely speculative. The key point, I suppose, for practitioners is going to be the need now, I think, in light of this decision, to supply evidence for contentions where it is asserted that there will be a loss of work, or that there will be adverse consequences commercially generally. The court aren't likely to accept generalized submissions, and I think the importance of Connors is to shift, albeit it doesn't say it in explicit terms, to thinking about putting our bases for those assertions very much in an evidential form. So that brings me to the end of my section, and I'm very grateful to you all for listening. I'm now going to hand over to Richard.
Thank you.
Sorry. I'm mindful of the time, and obviously we'll focus on the case law a little more than the statistics as well.
Yes, of course. Just to say that the worst offenders in terms of prohibition notices was the construction and manufacturing industry, although they were down from previous years on the latest figures that are, as we've heard, a little older. Surprisingly or unsurprisingly, education only had 6 in the 2019-20, so good on them, I suppose. So let's have a look at Shiva. Work at height is the largest cause of fatalities within the construction injury, so the HSE say in their statistics. It was therefore unsurprising that the inspector in this particular case was concerned about a suspended cradle on the exterior of the work premises and issued a notice, and another relating to the raising and lowering of a platform, working close to an unprotected edge and or about a cantilevered support. The company, upon which the prohibition notice had been served, appealed against the imposition of it and applied to stay the proceedings because the HSE had brought criminal proceedings and it would cause prejudice. Thank you. Next slide, Tom. Back one. The argument for a stay was on the basis that in order to conduct his appeal properly, he'd have to disclose evidence that would show that there'd been no serious risk of personal injury, and he'd be prejudiced in relation to the criminal proceedings. And the prosecution would be in a better position. It was held that the right not to incriminate oneself in civil proceedings was not infringed. There was no compulsion to incriminate in these circumstances. No prejudice caused by removing what was submitted would be the forensic advantage of surprise. Litigation by ambush, no more fair in criminal than in civil proceedings, said the court. The court also, incidentally, went on to say that he would have to anyway in the criminal proceedings by virtue of the service of a defense case statement and such, and the operation of the criminal procedure rules and the overriding objective there. In relation to the second ground, a rehearsal of case, the court applied mote. There was nothing prejudicial in principle about the prosecution rehearsing its case. It was not likely that the appeal process would assist the criminal prosecution, partly due to its nature, but also because the respondent had statutory powers to require any documentation necessary anyway. It's interesting, perhaps, the court, as noted by the judge, well, if he didn't want the HSE to know about it, he didn't have to appeal. I suppose he has a point there.
Richard, I suppose the appellants need only have asked a criminal hack what the latest state of law and practice is on disclosure and ambush and disclosure of defence statements to have known that these grounds of appeal were bound to fail.
Absolutely. Absolutely.
Next slide.
The next brings us to Broughton, which is not a health and safety case, as those who have read it will know. But it is gross negligence manslaughter. And we've included it because it puts in context a very recent decision of gross negligence manslaughter in the Crown against Wood Treatment Limited, with a judgment handed down on the 21st of April, certainly April, if not that particular date. Broughton was a very sad case indeed. It was the Bestival Festival, and the defendant had supplied his girlfriend with either a bumped up amount of 2CP or a combination of ecstasy and amphetamine. About 4:30 in the Sunday afternoon, they went into a nearby forest, a mere 85 meters outside the festival. Evidence in the case referred to being easily able to see the lights. Over the course of the evening, her condition just really went from bad to worse. She began hallucinating more intensely, and by the late evening, she was really in serious difficulties. During that period, the defendant was taking live photographs of her and videos. Also, throughout the evening, her family were pleading with him on the telephone and by text to get help for her. But he didn't, and ultimately she died. Ultimately, she was found about 1 o'clock in the morning, but may have died around 23:25. The prosecution case was that the defendant, Broughton, owed Loella a duty of care to secure medical help as her condition deteriorated to the point where her life was obviously in danger. And failing to do so, he was grossly negligent. And that was a substantial cause of her death. I needn't trouble you with these elements that needed to be proved for gross negligence manslaughter, but they're set out there in the judgment in Broughton. That is the cumulum, or the cumulative position of a number of recent authorities. The prosecution would have had to have proved to the criminal standard that gross negligence was at least a substantial contributory cause of death. That meant that the prosecution must be able to prove that Luella would have lived, in the sense that life would have been significantly prolonged. Importantly, to be sure that the gross negligence caused the death of Luella, the prosecution had to exclude realistic or plausible possibilities that she would have died anyway. And in the context of causation, in this very sad case indeed, the task of the jury was to ask whether the evidence established to the criminal standard with medical intervention as soon as possible after Luella's condition presented a serious and obvious risk to death, she would have lived. Had the prosecution excluded the realistic possibility that despite such treatment, she would have died. The professor giving evidence in the case, which is really all the jury had about it, on the issue of causation, was that his description of a 90% chance of survival of Luella at 21:10, were medical help available, leaves a realistic possibility that she would not have lived, which, if my maths is right, 10%. It's a very, very high standard for the prosecution to have met in this particular case, and the Court of Appeal held that the judge was wrong not to allow a submission of no case to answer at the end of the prosecution case.
Richard, the ratio of that case therefore made it much, much more difficult for prosecutions in these sorts of cases.
Oh, absolutely. And to illustrate that, forgive me.
I think your next case deals with that.
Yes. Is also in wood treatment. And if anything, it also highlights that in a gross negligence manslaughter case, there may be competing issues of causation that will require clearly expert evidence. This was Bosley Mill, owned and operated by the appellant company. Mr. Bowden was the managing director. The case was a terminatory appeal by the prosecution, the High Court judge trying it, allowing a submission of no case to answer on, for the company, corporate manslaughter charges, and for Mr. Bowden, the director, gross negligence manslaughter. There were also, forgive me, health and safety offences. The company pleaded to health and safety, and after the proceedings concluded, Mr. Bowden, it would appear, pleaded to the health and safety offence, but that by the by. Anyway, there was an explosion caused by the ignition of a cloud of wood dust in the air. It's a well-known risk. The prosecution case was supported by expert evidence, and in fact, there was a joint experts report that is set out more or less in the judgment. But there were, in essence, 4 possible ways that the explosion could have been caused. 3 of them, 1, 2, and 4, would have been arisen as a result of the prior accumulation of wood dust. The other possibility, scenario 3, was there was a sudden large release of dust from a failure of a piece of equipment. There was no dust present, as in the other 3 scenarios, in terms of this cause. So no reliance or no necessity there for the accumulation of dust that could ignite. The judge ruled that on the evidence, the explosion may well have happened if the company and Mr. Bowden had not been negligent in the manner alleged. There was no or sufficient evidence to prove negligent acts or omissions alleged against WTL and Mr. Bowden, that they played any substantial part in causing it. And as I've indicated, the prosecution appealed against that terminatory ruling. And at paragraph 37, we have what the court said. We accept the defense submission that on this state of the evidence, it was necessary for the prosecution to address scenario 3 in terms, understanding it didn't require a contribution to the explosion from the negligently accumulated wood dust, which permeated the mill. It meant that the prosecution evidence about those accumulations of dust could not prove the necessary causal link between the fault and the explosion. Therefore, it was necessary to examine scenario 3 and to evidence, if possible, the extent to which it must have inevitably have involved negligence, which could be proved against the company and personally attributed to Mr. Bowden. That exercise was not carried out, and no evidence on this issue was adduced. And it arose in this way. It was cross-examination of the expert in relation to a piece of equipment. The long and the short of it was that the prosecution sought to re-examine by really reaffirming the poor health and safety issues that were present in the mill. But the Court of Appeal said that was not enough. It would have required, said the judge, to jump between health and safety failings generally and the specific failure of plant posited by the experts under scenario 3, without any evidence, in effect, to speculate, to speculate about what a risk assessment might have said, recommended, or how any change of procedure implemented as a consequence of a risk assessment or written operating proceedings could have prevented a failure of equipment on the morning of the explosion. But there was no evidence of that. And it again illustrates that it really is becoming an almost impossible mountain to climb where you have multiple causes in
Richard,
gross negligence manslaughter cases.
Can I just make a couple of points in relation to this and invite your comment? Well, firstly, of course, we could have had the whole webinar on this case and on Broughton.
Oh, absolutely.
And in fact, I think another set of chambers is, in fact, doing exactly that in July.
Yes.
But would you agree with these propositions? Firstly, that wood treatment is a natural application, if not a slight extrapolation of Broughton. And secondly, that if one were to simplify, is this too great an oversimplification of wood treatment? That if there are two possible causes for an incident, and one of them is almost certainly the real cause, but the other one is more than merely negligible in terms of the likelihood of it, that if you can, as a defense lawyer, can put before the court the second non-negligible cause, then applying Broughton and wood treatment, the jury cannot possibly decide which of the two is the real cause, and therefore the defendant is acquitted. Is that a fair or oversimplistic
It is,
summary?
and in fact, Broughton was referred to in the judgment during the course of submissions and which was then replicated in the Court of Appeal on the terminatory application.
And therefore, in every case, but particularly in fatalities, it's incumbent on the defence to make sure that their expert examines every possible cause and then to focus on every plausible cause after that.
Yes.
All right, thank you.
So, I suppose staying with gross negligence, manslaughter, Morn, which is a coronial case of the Supreme Court. But I know that there were concerns about the impact of part of its judgment in relation to the lowering of the standard of proof in relation to conclusions of unlawful killing in inquests, either returned by coroner or coroner's jury. James Morn was a prisoner at HMP Bullingdon, and he was found hanging in his cell. His brother sought judicial review to quash the narrative decision or verdict. Well, it's not verdict anymore. Decision of an inquest jury. The deceased's his brother, who had intended to kill himself, and the direction of the coroner that the jury should answer questions on the balance of probabilities. So the judicial review was that the coroner had erred, and the background to the case as well was the section on the form 2 that has to be completed. The narrative comment was beyond reasonable doubt, and the short form the coroner used in this instance was the civil balance of probabilities. And throughout its appellate history, the courts were all in agreement, really, that as the Supreme Court, the standard of proof to be applied to the question of whether the deceased had died by suicide should be the civil standard and not the criminal standard, regardless of whether the conclusion was expressed by way of a short form or by way of a narrative conclusion. And they go on, as we'll see, to extend it to unlawful killing. Nothing in the common law or the Act demonstrated any cogent reason for not applying the general principle that the civil standard of proof should apply in civil proceedings. Application of the criminal standard might lead to suicides being under-recorded and to lessons not being learned. And certainly during the argument, the deceased was a Catholic, which suicide brought its own issues. But the changing role of inquests and changing societal attitudes and expectations confirm the need of reviewing the standard of proof in cases of suicide. And finally, leading Commonwealth jurisdictions had taken the same course. So there was no justification for maintaining it for suicide. And the next slide, please, Tom.
And Richard, I suppose on one view, it's surprising that it's taken so long to regularise every aspect of.
Yes, I mean, all the other short form conclusions were to the civil standard, for sure. The civil standard of proof should also be applied at an inquest to the question of whether the deceased had been unlawfully killed, regardless of whether the conclusion was expressed by way of a short form or narrative conclusion. And accordingly, the jury in the present case had applied the correct standard of proof in reaching their narrative conclusion. Will it make a difference? not according to the Chief Coroner. Next, please, Tom. And if anybody's interested, there's a hyperlink to the recent or the law sheet, which is guidance issued by the now new Chief Coroner, Honour Judge Teague, in relation, following Morn.
Richard, I suppose I should give a plug to our ex-member of Chambers who was the Chief Coroner, but who still, I think, is involved in a major inquiry.
He's involved in the Fishmongers Hall killing inquest, as it were. Unlawful killing. The Chief Coroner, to summarise the position, saying effectively there were many judicial statements to the effect that inquests were inquisitorial, fundamentally therefore distinct from criminal or civil trials. The decision in Morn emphasises that an inquest is a fact-finding exercise, not a method of apportioning guilt, which of course mustn't be done. At any inquest, and this is perhaps quite important, where unlawful killing may be an issue, it will now be particularly important for the coroner to explain the distinction between criminal proceedings and inquests. The explanation should set out the nature of the inquest process as a fact-finding inquiry with the objective of answering the questions that they have to: who, when, where, and how they came by his or her death, or in an Article 2 case, and in what circumstances. Where the coroner or the jury come to a conclusion of unlawful killing, that finding has no bearing on criminal proceedings, which are subject to a materially higher standard of proof, as well as different procedure rules. Thank you, Tom. The Chief Coroner indicated that unlawful killing has to be looked at in its wider context, and I apologise for any further statistics, but the nub of it was that there aren't very many of them. 166 conclusions of unlawful killing in 2019, 0.5% of inquest conclusions. Impact, according to the Chief Coroner, probably some continuing impact on the figures. But the issue of unlawful killing was likely to feature in very few cases. In those cases where it did, the Chief Coroner would expect coroners to take a well-reasoned and fact-specific approach when faced with submissions and or decisions as to the conclusions open. So, Tom,
Richard, can I just ask a quick COVID-related question?
You can try.
In relation to coroners' courts, the number of potential clients of solicitors who practice in this area may approach them in the next few weeks and months, saying, I've had a friend or relative die in hospital or in a care home as a result of COVID, and the care was atrocious, or that the staff weren't vaccinated. Those sorts of COVID-related questions. Do coroners now have a wider leeway to examine that, or has all of that been?
I don't necessarily think it's a wider. I don't necessarily think it's wider. Initially, the Chief Coroner issued guidance about it when there was a lot of concern about the lack of equipment, face masks for hospital staff and carers and so forth. There was different guidance or different focused guidance on by the Scottish senior coroner, as it were, and then a further guidance issued by the chief coroner, which effectively puts it down to the discretion of the coroner. But it's there in the coroner's guidance, COVID, and we can provide the particular guidance if necessary.
Thank you.
Where a conclusion of unlawful killing is one that is on the facts is open, the coroner will need to direct himself or the jury as to what elements need to be established for the offence that may be in play, and then to apply the civil standard to the facts as they relate to each element of the offence. There's a hyperlink to law sheet number 1 on unlawful killing, sets out the elements of the offence, which has also been set out in a previous slide, particularly of gross negligence manslaughter. MORN does not affect the law or the case law in relation to that. Each of the elements of the offence of gross negligence manslaughter must be established on the balance of probabilities before a coroner or jury may return a conclusion of unlawful killing based on the offence of gross negligence manslaughter. Although it's, I suppose you could say, as does Bridget Dolan in her blog, Queen's Counsel, how can you apply a civil standard to the question of whether, having regard to the risk of death involved, was this misconduct grossly negligent so as not to be condemned as, well, effectively, the worst possible criminal conduct that results in death? There is a tension, perhaps.
I suppose an answer is to separate out the legal test from the evidential test.
Yes.
Although you do need a bit of mental gymnastics to be able to do that.
Exactly. So, thank you. Resumptions, where, for example, an inquest has been opened and adjourned, as before, unchanged, and in terms of the consequences, an acquittal of a defendant following a criminal trial doesn't automatically mean that a coroner will need to resume the inquest. The jury would have heard all the evidence, there'd have been an investigation, the rights of the families of family of the bereaved wouldn't be offended. So it doesn't necessarily follow. By the same token, a conviction or plea at trial does not automatically mean that there's a need, that there need be no resumption of the inquest. And in either scenario, there may be issues requiring further public investigation that necessitate a resumption. In Grice, coroner were correct to reopen an inquest into the murder of a woman who'd been killed by her former partner, and the police had mishandled the investigation. The coroner didn't need to reopen the inquest because collectively, with the police investigating the police and all the various hearings that had taken place relating to that, the Article 2 obligation had been met. So there wasn't a need, as it were, to hold an inquest. It was obvious to everyone over the years about those conclusions. Thank you. Consistency, that too is unchanged. If an inquest is resumed following a criminal trial of a homicide offence, the inquest may not be inconsistent with the outcome of the criminal proceedings. In such an inquest, if the coroner or jury find that the requisite elements of murder or manslaughter or infanticide are established on the balance of probabilities, then a conclusion of unlawful killing will be permissible, even though there has already been an acquittal of the offence following a homicide trial. Such an inquest conclusion would not be inconsistent with a criminal jury having already found that they weren't sure of the very same matters to the criminal standard. On that point, of course, there is very old authority to say an acquittal in a criminal case is not a declaration of innocence. It is simply that the jury could not be sure on the evidence.
That confirms a long line of authorities in
Indeed.
conspiracy cases, where
Yes.
one conspirator can be acquitted in a close conspiracy, but the other one convicted. And the Court of Appeal have repeatedly said it doesn't necessarily follow that, therefore, the guilty man must have been innocent.
Yes, absolutely. If there has been a trial, a criminal trial, where a person has been convicted of a homicide offence, then the coroner or jury at an inquest couldn't reach a conclusion to the effect that the offence had not been committed. So that remains unchanged by Morn. And finally on this, do we really need to use the words unlawful killing in any event? No legal requirement to, no requirement for any particular form of words. The Form 2 record of inquests doesn't codify the law, as the Supreme Court said, and short form conclusions, of which unlawful killing is one, is not required to be returned as a matter of law, whether as part of a longer narrative or standing alone. Rather, it is for the coroner or the jury, under the coroner's directions, to choose the appropriate form of words to reflect the findings of fact on the critical issues relating to the death.
Richard, we probably have about 10 minutes in which to,
oh yes, right, okay,
canter through the rest of the slides.
Certainly. Okay, Sentencing Act came in. Most important thing is that it's much as before, but codified, put into a user-friendly position, and brings together all the sentencing legislation and puts it into a single act. The Law Commission say 13,000 pages down to 450. Well, there we are. Happy days. Yes, it's meant to make it simpler for everyone. And in my use of it thus far, I entirely agree. It's doing what it says on the tin. And if we can just flick through the sides, Tom, we set out for you there what it doesn't do and what it does do. And there's an index. Next slide, Tom. No harsher penalties. The most important consideration is the transitional provisions. It is, as the first slide said, if the conviction takes place before the 1st of December, when it came into force, the old provisions apply. Not that it makes the slightest bit of difference, but it's even if the sentence, if a person is sentenced after the 1st of December 2020, the new provisions apply only in cases where conviction is after the implementation date of the 1st of December. But it's academic in any sense, because there is no change, except it's easier to understand. Thank you. And yes, there is where you will find the various portions. And these are the links should you wish to look, and I understand that they're hyperlinked.
And Richard, everyone that's logged in, as well as those that have expressed an interest in this webinar, will receive each one of these slides and with the hyperlinks.
Yes. Then Attorney General's guidelines on disclosure, effective from the 31st of December 2020. This is important. And I've set out the main and core principles, but it clearly came about because of various prosecution failings with the Crown Prosecution Service and well documented and publicised cases, particularly involving sexual offences and mobile phones. Tom, if you could, next slide, please. The structure places emphasis on important principles: right to a fair trial and balance, the disclosure exercise to be conducted in a thinking manner, not box ticking. It places importance on the role of the reviewing lawyer centrally, and skilled disclosure officers. Next slide, Tom. Carry on there. Thank you. Thank you. Go on again. Thank you. Thinking manner. There we are. Not simply a schedule completing exercise, and not undertaking the process in a mechanical manner, keeping the issues in mind, being alive to the countervailing points of view, considering the impact of the disclosure decisions, keeping disclosure decisions under review. Thinking outside the box, really. Next slide, Tom. Next slide. Interestingly, and to make it easier, the new guidelines and the code follow the course of a criminal investigation. Starts with the investigation, finishes at the end of the proceedings in terms of sentence. One thing of importance brought in, pre-charge engagement. It was encouraged by authority, judicial authority before, and I've set out there when it does apply and when it should not. But it really encourages, put it in a line.
Sorry to interrupt.
Yep.
What is the new test then for disclosure? Because that's what...
test hasn't changed. Mm-hmm. All that's changed is the focus and emphasis.
And therefore, what is the advantage that the defence have that can be utilised? Because, of course, in an average criminal case, it probably makes not a huge amount of difference because there is not a great opportunity for defence lawyers to engage. But in the average health and safety case, when one's defending, particularly complex cases where there are companies and directors involved, do you think there is a greater opportunity now to engage and therefore to put the prosecution on the back foot with early engagement?
Yes, I do. I've always been an advocate of pre-charge engagement because, if nothing else, nobody can complain down the line that something wasn't done. If it genuinely is important to your defence, it may result in not being charged in certain circumstances because the authorities have been given information that they might not have got or thought about before in terms of lines of inquiry and what are reasonable or not. You know, ultimately, prior to pre-charge engagement, unless it was done on a voluntary basis, and it is voluntary and informal, the police really had sometimes the regulators as well, no comment. So you have to try and work it out for yourself, really, on the facts. So it's aimed at stopping problems further down the line, and a real focus back on disclosure and doing it properly.
And of course, just one final point on that, that if the defence don't engage in circumstances where they should, it may be a source of criticism during a trial process if the defence then seek disclosure, because a prosecution response may well be, but hold on a minute, this is in breach of what was the new scenario, and therefore you really should have engaged earlier, and it's a bit late now to ask us to carry out a huge exercise.
Yes, but it's limited, I believe. You can't. Yes, ultimately it may be, but you can't hold it against somebody that they haven't cooperated. It's an entirely voluntary process. But if you were to make an abusive process application later down the line, then you may have a ruling against you for not pursuing or not raising that earlier.
Richard, I'm sorry to push you for time.
No, one more thing in disclosure, please. CMDs or DMDs, rather, disclosure management documents, mandatory by the prosecution by initial disclosure in the Crown Court, discretionary in the Magistrates' Court. Back to you, Tom.
Okay, thank you very much, Richard. I just thought we'd end by looking ahead at some of the key initiatives that the HSE have in store for 2020 and 2021. You can see here they've got 5 objectives. I'm going to focus on 3 of them. The first is that they endeavour to provide an effective regulatory framework focusing on what's called the BSR, which is a new government building safety regulator, which will be an arm of the HSE and is obviously no doubt a response to the concerns that were revealed about high-rise residential buildings as a result of the Grenfell Tower incident. Secondly, the COVID-19 is providing significant hurdles in terms of risk management for, in particular, companies which and sectors which were initially considered low risk, but are now very high risk by virtue of the virus. So there are industries which are not familiar with grappling with the demands of health and safety legislation in the same way as perhaps construction clients may be, who will now have to face a heightened control of risk in relation to COVID-19. And finally, in relation to the third point, their aim is obviously, as it would be, to reduce the likelihood of low frequency but high impact catastrophic incidents, which can damage public confidence in particular sectors. In relation to this objective, it's going to focus on the decommissioning of oil rigs, in particular as a sector. So you may find increasing clients looking for advice in that particular sector, as well as the cybersecurity of major hazard industries to ensure that the cybersecurity of those companies doesn't put the public and society at risk. I'm going to leave it there. I do have further slides, but I suspect that's a presentation all in its own right, in particular the building safety regulator.
Absolutely. Tom, Richard, perfect timing. I must confess you two have spent many, many days preparing for this. I haven't, thank goodness, but I'm surprised that during a COVID year, in fact, how much there is to learn to catch up. And as you've said, Richard, we could have had a much longer seminar or a series of seminars.
On one of those cases alone, certainly.
And so all I can say to those that have logged in, thank you very much. Even though we've got a very large regulatory group in Chambers, it's right to say that this was the first health and safety webinar that we've run. We've had a series of other webinars throughout the last year. But thank you very much, and we look forward to seeing you at the next webinar.